The gavel's echo still rings in my ears 3 years later. Not because of the sound itself, but because of what followed, the stunned silence, my mother's gasp, and my father's face draining of color as he realized his failure of a daughter had just accomplished something he never thought possible. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow, I've saved something extra special for you. My name is Elena Vasquez, and for 26 years, I lived in the shadow of my parents' disappointment. Growing up in the small industrial town of Millbrook Heights, I was the daughter who couldn't do anything right. While my brother Marcus excelled in engineering like our father wanted, I stumbled through school, struggled with traditional academics, and seemed to drift aimlessly through life. Elena will never amount to anything, my mother, Carmen, would whisper to her sisters during family gatherings, thinking I couldn't hear. She's too scattered, too emotional. She doesn't have what it takes to succeed in the real world. My father, Roberto, was even more direct. A successful factory supervisor who'd worked his way up from the assembly line, he believed in concrete achievements, degrees, certifications, steady paychecks. When I dropped out of my business program at Riverside Community College after 2 semesters, he looked at me with a mixture of disappointment and resignation that cut deeper than any harsh words could have. "I don't understand you, Elena," he said that night, sitting across from me at our worn kitchen table. "Your brother gets it. Work hard, follow the rules, build something stable. But you're always chasing some dream that doesn't make sense." What he didn't understand was that I wasn't chasing dreams, I was running from a nightmare. The nightmare of feeling invisible, of being dismissed, of watching other people's lives move forward while mine stood still. I took whatever jobs I could find, waitressing at Murphy's Diner, stocking shelves at the local pharmacy, cleaning offices downtown. Each job felt like confirmation of what my parents already believed, that I was destined for mediocrity. But something shifted the day I witnessed an accident at the intersection of 5th and Main Street. A delivery truck had run a red light and slammed into Mrs. Chen's sedan. She was an elderly woman who lived 2 blocks from us, and watching the paramedics work while she lay unconscious on the asphalt, something awakened in me. The truck driver immediately started claiming the light was yellow, that Mrs. Chen had been speeding, that it wasn't his fault. But I had seen everything. I had watched him texting while driving, seen him barrel through that intersection without even slowing down. When the police took statements, I spoke up clearly and firmly, describing exactly what I had witnessed. That night, Mrs. Chen's daughter, Lisa, called me. "Elena, the insurance company is trying to deny my mother's claim. They're saying it was her fault. Would you be willing to testify about what you saw?" I said yes without hesitation. But as the weeks passed and I learned more about the legal process, I realized something troubling. Mrs. Chen's lawyer was overwhelmed, understaffed, and seemed to be going through the motions. Meanwhile, the trucking company had hired a team of aggressive attorneys who were twisting facts, burying important evidence, and intimidating witnesses. "This isn't right," I told Lisa after a particularly frustrating meeting with her lawyer. "Your mother is lying in a hospital bed, and these people are trying to steal her compensation so they can protect their profits." "I know," Lisa said, tears in her eyes. "But what can we do? We can't afford better lawyers." That night, I couldn't sleep. I kept thinking about Mrs. Chen, about all the other people who get crushed by systems designed to protect the powerful while abandoning the vulnerable. For the first time in my life, I felt a pull towards something meaningful, something that mattered beyond my own small world. I started researching. I spent hours at the public library, reading about personal injury law, studying case precedents, learning about legal procedures. I attended community college courses in paralegal studies, paying for them with money I saved from my restaurant shifts. My parents thought I was wasting time again. Another phase, my mother sighed to her friend Rosa. Last year it was photography, before that it was massage therapy. She never sticks with anything long enough to succeed. But this felt different. For the first time, I wasn't running towards something because I was trying to escape my life. I was running towards something because I had found my purpose. I volunteered at the legal aid clinic downtown, filing paperwork and organizing case files. I shadowed attorneys during consultations, absorbing everything I could about how the law actually worked. And slowly, I began to see a pattern. The same people kept getting hurt by the same systems, over and over again. Workers injured by negligent employers who knew how to manipulate workers' compensation. Families destroyed by medical malpractice cases that dragged on for years while insurance companies played delay tactics. Elderly residents of nursing homes who suffered abuse because their families didn't know how to fight back against corporate legal teams. The more I learned, the more determined I became. And the more determined I became, the more my parents worried that I was setting myself up for another failure. "Elena, you need to be realistic," my father said one evening after I told him I was applying to law school. "This isn't like your other projects. This is serious, and it's expensive, and it requires a different kind of mind than you have." "What kind of mind do I have, Dad?" I asked quietly. He paused, perhaps realizing how his words sounded. "You know what I mean. You're creative, you're caring, but law is about logic and precision and you've never been good at those things." That conversation happened on a Tuesday night in March. 3 years later, I would walk into a courtroom and prove him wrong in ways that neither of us could have imagined. But this story isn't just about proving my parents wrong. It's about what happened when I finally stopped trying to become the person they wanted me to be, and started becoming the person I was meant to be. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel, it means a lot to us. Now back to the story. 3 rejection letters sat on my desk like tombstones marking the death of a dream. Northwestern, Georgetown, and Boston University had all delivered the same verdict: while your passion for justice is evident, your academic record does not meet our standards for admission. I stared at the letters until the words blurred together. Maybe my parents were right. Maybe I was fooling myself, chasing another impossible dream while my life slipped away one disappointed conversation at a time. "Mija, maybe it's time to consider something more practical," my mother said gently, finding me at the kitchen table surrounded by crumpled application materials. "There's nothing wrong with being a paralegal. You could still help people, but without all this stress." My father appeared in the doorway, home from his shift at the plant. He took in the scene, me, the rejection letters, my mother's concerned expression, and I saw something flicker across his face. Not satisfaction exactly, but perhaps relief that this particular dream was ending before I could fail publicly. "Elena, I know this hurts," he said, sitting down across from me. "But sometimes life has a way of protecting us from paths that aren't meant for us. You've got good skills, a kind heart. There are plenty of ways to build a decent life without putting yourself through this kind of disappointment." That night, I lay awake thinking about paths. About the difference between the path you choose and the path that chooses you. About Mrs. Chen, who had finally received a settlement from the trucking company after I helped her daughter find a better lawyer and provided detailed testimony about what I'd witnessed. About the families I'd met at the legal aid clinic, people who needed advocates who understood what it felt like to be dismissed and overlooked. The next morning brought an email that changed everything. Riverside University School of Law, a smaller, less prestigious institution about an hour away, was offering me conditional acceptance into their evening program. Conditional on maintaining a 3.5 GPA and completing a summer preparatory course in legal writing. It wasn't Harvard. It wasn't even close. But it was a door, and I had learned that sometimes the right door isn't the most impressive one. My parents' reaction was predictably mixed. My mother worried about the expense, the time commitment, the possibility of another failure. My father was more direct. "Evening law school while working full-time? Elena, that's a recipe for disaster. You'll burn out in 6 months, waste money we don't have, and end up back where you started but with student loan debt." "Maybe," I admitted. "But what if I don't?" He shook his head. "That's not how you make major life decisions. You look at probabilities, not possibilities." But I was tired of living by probabilities calculated by other people's fears. For once in my life, I wanted to bet on myself. The summer preparatory course nearly killed me. After 8-hour shifts at Murphy's Diner, I would drive to Riverside and sit in a classroom with 19 other conditional admits, learning to think like a lawyer. We studied contract law basics, constitutional principles, and legal reasoning. But more than that, we learned to argue, not emotionally, but systematically, building cases brick by brick. Professor Martinez, a former public defender who taught the course, had a way of pushing us beyond our comfort zones. During our first mock trial exercise, I found myself defending a hypothetical client accused of shoplifting. As I stood before my classmates playing jury members, something clicked. "Ladies and gentlemen," I heard myself saying, "my client isn't on trial just for allegedly taking a candy bar. She's on trial for being poor in a system that criminalizes poverty. She's on trial for being desperate in a society that punishes desperation rather than addressing its causes." The room was quiet when I finished. Professor Martinez nodded slowly. "Ms. Vasquez, that was the most compelling opening I've heard in 5 years of teaching this course. You have something many law students never develop, the ability to see the human story inside the legal framework." I called my parents that night, breathless with excitement, trying to explain what had happened in class. But their response was cautious, guarded. "That's wonderful, Mija," my mother said. "But remember, it's just the beginning. You have 3 years ahead of you." My father was even more reserved. "Don't let one good day convince you this is going to be easy. Law school is different from those preparatory classes." He was right, of course. The first semester of actual law school was brutal. Criminal law, contracts, constitutional law, and legal research, for courses that each demanded more reading and analysis than I'd ever attempted. I would work my restaurant shift from 6 a.m. to 2 p.m., drive to campus, attend classes from 6 p.m. to 10 p.m., then study until midnight before starting the cycle again. My classmates were mostly older, working professionals like me, but many had business backgrounds or previous legal experience. I felt constantly behind, struggling to decode case law while they seemed to navigate legal reasoning naturally. The breaking point came during my first semester finals. I was so exhausted that I fell asleep during my contracts exam, waking up with 20 minutes left and half the questions unanswered. When I called home that night, crying from frustration and fear, my mother's response was gentle but devastating. "Mija, maybe this is God's way of telling you that you've pushed far enough. There's no shame in admitting something isn't working." But Professor Martinez had told us something on the first day of class that echoed in my mind. The law isn't about being the smartest person in the room. It's about being the most persistent. I retook that contracts exam during the makeup period, scoring well enough to pass the class. But more importantly, I learned something about myself that winter. I learned that when everything in my body wanted to quit, when every logical voice was telling me to give up, there was something deeper that refused to surrender. My parents watched this struggle with a mixture of admiration and concern. They saw me working 18-hour days, saw me missing family gatherings and social events, saw me growing thinner and more intense with each passing semester. "I'm worried about you," my father said during one of my rare visits home. "This isn't sustainable, Elena. And even if you finish, what then? You'll graduate with massive debt and no guarantee of finding a good job." "I'm not doing this for money, Dad," I told him. "Then what are you doing it for?" he asked, genuine confusion in his voice. I thought about Mrs. Chen, about the families at the legal aid clinic, about all the times I'd felt powerless to help people who deserved better. "I'm doing it because someone needs to care about the people nobody else cares about," I said. He was quiet for a long moment. Then he said something that surprised me. "You know, Elena, I've never understood you. But I'm starting to think that maybe I don't need to understand you to be proud of you." It was the closest thing to encouragement he'd ever given me, and I carried it through the next 2 years like a talisman against doubt. But neither of us could have imagined where that encouragement would lead, or the moment when everything we thought we knew about justice, family, and fighting for what's right would be tested in ways that would change our family forever. By my 3rd year of law school, I had developed a reputation. Not the kind my parents had hoped for when they grudgingly accepted my decision to pursue law. I wasn't the star student who would graduate summa cum laude and join a prestigious firm. Instead, I was known as the woman who took on impossible cases at the legal clinic, the one who would spend her weekends researching obscure precedents for clients who couldn't afford to pay. The case that would define everything started on a rainy Tuesday in October. I was manning the intake desk at the Riverside Legal Aid Clinic when Maria Santos walked through the door, clutching a folder of papers and looking like she hadn't slept in weeks. She was maybe 50, with calloused hands and eyes that held the kind of exhaustion that comes from fighting a system designed to wear you down. "They fired my son," she said in accented English, her voice barely above a whisper. "They fired him and now they say he was stealing, but he wasn't. He was trying to protect the other workers." Her son, David Santos, had been working at Meridian Manufacturing, the largest employer in Millbrook Heights. For 3 years, he'd operated heavy machinery on the factory floor, the same kind of work my father had done his entire career. But according to Maria, David had been documenting safety violations that the company was covering up. Missing safety guards on equipment, inadequate ventilation systems, pressure to work through safety protocols to meet quotas. He reported it to his supervisor, Maria explained, spreading out photographs on my desk. "These pictures show the broken equipment, the safety tags that were removed." But instead of fixing the problems, they accused him of theft and fired him. Now he can't find work anywhere, and the company is spreading rumors that he's a criminal. I studied the photographs. Even with my limited knowledge of factory operations, I could see obvious OSHA violations. Equipment that should have been tagged out of service was running with missing guards. Workers were operating machinery without proper safety equipment because, according to Maria, the company had cut costs by reducing safety gear purchases. "Has David filed a complaint with OSHA?" I asked. Maria's laugh was bitter. "You don't understand. Meridian owns this town. The mayor, the city council, half the police force, they all depend on that company. David filed reports, and they disappeared. He tried to contact OSHA directly, and somehow his supervisors knew about it before the inspector ever showed up. This was exactly the kind of case that Professor Martinez had warned us about in our employment law seminar. Corporate retaliation against whistleblowers was notoriously difficult to prove, especially in small towns where economic power concentrated in the hands of a few major employers. Companies like Meridian had refined the art of destroying whistleblowers' credibility before their accusations could gain traction. "Mrs. Santos, I need to be honest with you," I said carefully. "Cases like this are extremely challenging. The legal costs alone could be substantial, and companies like Meridian have teams of lawyers specifically trained to fight whistleblower claims." Her shoulders sagged, and I could see the last bit of hope leaving her eyes. "So there's nothing we can do? They can just destroy my son's life and move on?" Something in her voice reminded me of my own mother, the resignation that comes from a lifetime of being told that some fights are too big for people like us. But it also reminded me why I was sitting in that clinic instead of studying corporate law like most of my classmates. "I didn't say there was nothing we could do," I corrected. "I said it would be challenging. Let me look into David's case more thoroughly. Can you have him come in tomorrow to meet with me?" David Santos was 28, about my age, with the same intense eyes as his mother and hands scarred from 3 years of factory work. When he walked into the clinic the next day, he moved carefully, like someone who had learned to expect trouble. "I appreciate you meeting with me, Ms. Vasquez," he said, "but I'm not sure this is worth your time. Meridian has already won. They've made sure I can't get work anywhere in the county, and fighting them will just make things worse for my family." I had heard variations of this speech from dozens of clients, the preemptive surrender that happens when people have been beaten down by systems too large and complex to fight alone. But as David told me his story, I began to understand that this wasn't just about one fired worker. This was about a pattern of corporate behavior that put dozens of workers at risk every day. "David, you documented these safety violations for months before you were fired. Why didn't you just quit and find another job?" His answer was simple and devastating, because my co-workers were getting hurt, and I was the only one with enough English and education to understand what the safety regulations actually said. If I left, who would speak up for them? That night, I spread David's documentation across my apartment floor. Photographs of broken equipment, copies of safety reports that had been ignored, testimonies from workers who had been injured when safety protocols were bypassed. It was compelling evidence, but it was also exactly the kind of case that could destroy a young lawyer's career if it went wrong. I called my mentor, Professor Martinez, at home. "Elena, I've seen cases like this before," she said after I explained the situation. "Meridian Manufacturing has been accused of retaliation several times over the past decade. They always settle out of court with confidentiality agreements, which means there's no public record of the pattern. But that also means they have a lot of experience making these cases disappear. So you think I shouldn't take it? I think you should be very careful about how you take it. Companies like Meridian don't just fight legal cases, they fight to destroy the credibility and career prospects of lawyers who challenge them. Are you prepared for that level of conflict?" I thought about my parents, about their years of warning me against taking on fights I couldn't win. About my father's belief in following rules and avoiding risks. About the safe path of joining an established firm and handling routine cases for middle-class clients. "Professor, what would you do?" "I would probably advise you to refer the case to a more experienced employment attorney," she said honestly. "But I would also tell you that sometimes the most important cases are the ones that scare us the most." Over the next 2 weeks, I researched Meridian Manufacturing exhaustively. What I found was a company that had mastered the art of regulatory capture. They hired former OSHA inspectors, donated heavily to local political campaigns, and maintained a network of relationships that made them nearly untouchable at the local level. But I also found something else. 3 similar cases in other states where factory workers had been fired after reporting safety violations. In each case, the workers had been accused of theft or misconduct, their credibility destroyed before their whistleblower claims could be properly investigated. The pattern was clear, but proving it would require resources and expertise far beyond what a law student could provide. I was preparing to refer David's case to a larger firm when I received an unexpected phone call. "Ms. Vasquez, this is attorney Rebecca Chen. I understand you're working with David Santos on a potential whistleblower case against Meridian Manufacturing." Rebecca Chen. I knew the name. She was a partner at Chen and Associates, a plaintiff's employment firm in the state capital. More importantly, she was the daughter of Mrs. Chen, the elderly woman whose car accident case had first sparked my interest in law. "My mother told me about the work you did on her case," Rebecca continued. "She said you were the only person who cared enough to dig deep and find the truth. I've been looking for someone local to partner with on a case against Meridian. Someone who understands the community and isn't intimidated by corporate pressure. Would you be interested in collaborating?" It was the kind of opportunity that comes once in a lifetime, a chance to work with an experienced attorney on exactly the kind of case I was passionate about. But it was also terrifying. Taking on Meridian Manufacturing would mean challenging the most powerful employer in my hometown, risking my career before it had even begun, and potentially confirming every doubt my parents had ever expressed about my judgment. "Ms. Chen," I said, "I should tell you that I'm still a law student. I won't even graduate for another 6 months." "I know," she replied. "But sometimes the best advocates are the ones who still remember why they wanted to practice law in the first place. Are you willing to fight for David Santos and the other workers at Meridian?" I looked out my apartment window toward the lights of Millbrook Heights, where my parents lived and where dozens of workers like David risked their safety every day in jobs they couldn't afford to lose. "Yes," I said. "I'm willing to fight." I had no idea that this decision would eventually lead me to a courtroom confrontation that would test everything I believed about justice, family loyalty, and the courage it takes to stand up to power. All I knew was that for the first time in my life, I was exactly where I was supposed to be. Working with Rebecca Chen was like stepping into a different universe of legal practice. While I had been accustomed to the cramped quarters and limited resources of the legal aid clinic, her firm operated with the precision and efficiency of a well-funded machine dedicated to taking on corporate giants. Our first strategy meeting took place in her downtown office, a sleek space with floor-to-ceiling windows overlooking the state capitol building. David Santos sat between his mother and me, still carrying that careful wariness of someone who had learned not to hope too much. "David, I want you to understand what we're up against," Rebecca said, spreading out a thick folder of documents. "Meridian Manufacturing has annual revenues of over $2 billion. They employ 12,000 people across 4 states. They have a legal department with 37 attorneys and contracts with at least 6 major law firms for specialized litigation. David's mother gripped his hand tighter. Maybe this is a mistake, she whispered in Spanish. But Rebecca wasn't finished. They also have a documented pattern of retaliating against workers who report safety violations. In the past 5 years, we've identified at least 12 similar cases across their facilities. Workers who reported problems were subsequently fired for allegedly unrelated reasons, and then found themselves unemployable in their local job markets. She pulled out a timeline that showed the pattern: safety complaints filed, sudden performance issues discovered, termination for cause, and systematic character assassination that followed the workers wherever they tried to find new employment. The difference with your case, David, is that you documented everything. You understood the legal implications of what you were seeing, and you created a paper trail that most workers wouldn't have known to establish. I studied the timeline, feeling a mixture of excitement and terror. This shows clear retaliation, but how do we prove it? Meridian will argue that David's termination was based on legitimate performance concerns. Rebecca smiled. That's where you come in, Elena. You know this community. You understand how Meridian operates in Millbrook Heights, how they use their economic power to control information and silence opposition. We need someone who can investigate locally, who can talk to workers and build trust in ways that outsiders can't. Over the next month, I found myself living a double life. By day, I attended my final semester classes, completing the coursework necessary for graduation. By night and on weekends, I conducted what amounted to an undercover investigation of Meridian manufacturing. The work was dangerous in ways I hadn't anticipated. Not physically dangerous, but dangerous to my future career prospects and my family's standing in the community. Meridian's influence extended everywhere in Millbrook Heights. The company sponsored the high school football team, donated to the annual church fundraisers, and employed relatives of nearly every family in town. My first breakthrough came through Rosa Martinez, a cleaning woman at Meridian who had known my mother for 20 years. Rosa worked the night shift, cleaning the administrative offices and factory floor after production stopped. She had access to areas that day shift workers never saw, and she noticed things that others overlooked. Elena, you have to be very careful, Rosa warned me when we met at a coffee shop 3 towns away from Millbrook Heights. The supervisors, they watch everything. They listen to phone calls, they read employee emails, and they have people who report conversations in the break rooms. But Rosa had seen the same safety violations that David documented, and she had witnessed the systematic harassment of workers who asked too many questions. More importantly, she had access to something that could prove our case: the company's internal communications about David's situation. The night after David was fired, I was cleaning the manager's office. Mr. Harrison was still there, on a conference call with corporate headquarters. I heard him say that they needed to make an example of David so other workers wouldn't get ideas about going to the government. This was exactly the kind of direct evidence of retaliation that could make our case, but getting Rosa to testify would put her job and her family's financial security at risk. She was a single mother with 2 children, and finding comparable employment in Millbrook Heights would be nearly impossible if Meridian blacklisted her. I want to help David, she said, but I can't lose my job. My kids depend on that income. I understood her dilemma completely. It was the same calculation that kept most workers silent when they witnessed corporate wrongdoing. The system was designed to make the cost of speaking truth too high for ordinary people to bear. But Rebecca had anticipated this problem. We can apply for witness protection under the whistleblower statute, she explained. If Rosa testifies, she'll be legally protected from retaliation, and if Meridian fires her in response to her testimony, we can add her case to the lawsuit. Legal protection is different from practical protection, I pointed out. Even if we win a retaliation case for Rosa, that won't pay her bills or feed her children during the months or years it takes to resolve. This was the moment when I fully understood what Professor Martinez had meant about the cost of fighting for justice. It wasn't just about legal fees or time investment, it was about asking ordinary people to sacrifice their security for principles that might not pay their rent. The ethical complexity deepened when I discovered that Meridian had recently hired my father as a contractor to upgrade some of their electrical systems. Roberto Vasquez had finally been offered the kind of high-paying, prestigious project that he had worked toward his entire career. The irony was devastating. My father's professional success was now directly tied to the company I was preparing to sue. I wrestled with whether to tell him about my involvement in the case. On one hand, he deserved to know that his daughter's legal work might impact his business relationship. On the other hand, telling him would put him in an impossible position and potentially compromise our investigation. The decision was made for me when my mother called one evening, excited to share news about my father's new project. "Elena, your father is so proud. Meridian chose his company over 3 other bidders for a 6-month electrical upgrade project. This could lead to more work with big companies, maybe even a chance to expand his business." I felt sick listening to her enthusiasm, knowing that our lawsuit could destroy this opportunity that meant so much to my parents. But I also thought about David Santos, unemployed and struggling to support his family because he had tried to protect his co-workers from dangerous conditions. That night, I called Rebecca with my concerns. "Elena, this is exactly why corporate defendants choose smaller communities for their operations," she said. "They create economic dependency that makes it nearly impossible to challenge them. Your father's contract with Meridian isn't coincidence. They've probably researched your family background and offered him this project specifically to create a conflict of interest." "Are you saying they know about my involvement in David's case?" "I'm saying they know you're a law student, they know you're from Millbrook Heights, and they know you've been asking questions. Companies like Meridian have sophisticated intelligence operations designed to identify and neutralize threats before they become serious problems. This possibility had never occurred to me. The idea that my family might be unwitting pawns in Meridian's strategy to undermine our case was both infuriating and frightening. "What do we do?" I asked. "We document everything, we proceed carefully, and we remember that David Santos trusted us with his case because he believes justice is more important than convenience. But believing in justice was easier when the costs were abstract." As I prepared for my law school graduation, knowing that our lawsuit against Meridian would be filed immediately afterward, I was forced to confront the possibility that fighting for what was right might mean sacrificing my family's financial security and my own future in the legal profession. I was about to learn that sometimes the biggest battles aren't fought in courtrooms, they're fought at kitchen tables, where families discover that their deepest values are in conflict with their immediate interests. The phone call came at 6:47 a.m. on a Wednesday morning, 3 weeks before my law school graduation. I was reviewing employment law notes when my father's voice, tight with controlled anger, cut through my concentration like a blade. "Elena, we need to talk. Now." I had been dreading this moment since Rebecca and I filed the initial paperwork for David Santos's case. Despite our efforts to keep the investigation confidential, word had begun to spread through Millbrook Heights in the way that secrets always do in small towns, through whispered conversations, knowing glances, and the invisible network of relationships that connect everyone to everyone else. "Dad, I can explain." "Not over the phone. Meet me at Murphy's Diner in 20 minutes. Murphy's Diner at 7 in the morning was filled with factory workers grabbing coffee before their shifts, contractors discussing jobs over breakfast, and retirees solving the world's problems over bottomless cups of coffee. It was also neutral territory, a place where my father and I could have a difficult conversation without the emotional weight of sitting in our family kitchen. I found him in a corner booth, still wearing his work clothes from what had obviously been a sleepless night. His face carried the expression I remembered from my childhood when I had disappointed him in ways that went beyond simple mischief, a mixture of hurt, anger, and bewilderment that cut deeper than any shouting could have. "Sit down, Elena," he said quietly. I slid into the booth across from him, my hands trembling slightly as I reached for the coffee cup that the waitress had automatically filled. The silence stretched between us until my father spoke, his voice carefully controlled. "Yesterday afternoon, Frank Harrison from Meridian called me into his office. He told me that my daughter was working with outside lawyers to sue his company. He told me that the electrical contract I'd been working on for 3 months, the contract that was going to allow me to hire 2 additional employees and bid on bigger projects, was being terminated immediately." The words hit me like physical blows. I had known this was possible, but hearing the reality of it made me feel sick with guilt and responsibility. "Dad, I'm sorry. I never wanted this to affect your business, but..." But you did it anyway. His interruption was quiet but devastating. Elena, do you have any idea what you've done? Not just to me, but to your mother, to our family's reputation in this community? I forced myself to meet his eyes. I'm trying to help a worker who was illegally fired for reporting safety violations that could have gotten people killed. People like me, you mean? My father's laugh was bitter. Elena, I've worked in factories for 30 years. I know about safety violations, I know about corporate pressure, and I know about the choices working people have to make every day. But I also know that you can't fight every battle, especially when fighting means destroying the people you claim to be protecting. David Santos was fired for doing the right thing. He documented dangerous conditions that Meridian was covering up, and they destroyed his career to silence him. And now they've destroyed mine too. Was that part of your plan? The accusation stung because it contained enough truth to be devastating. I had known that taking on Meridian might affect my father's business, but I had chosen to proceed anyway, telling myself that justice was worth the risk. Dad, what Meridian did to you is illegal. It's retaliation for my legal activities, and we can add it to the lawsuit. I don't want to be part of your lawsuit. The force of his response caused several nearby diners to glance in our direction. He lowered his voice but maintained the intensity. Elena, I want to work, to support my family, to live peacefully in the community where I was born. I don't want to be a symbol in your crusade against corporate America. I stared into my coffee, trying to find words that could bridge the gap between my father's practical concerns and my conviction that some fights were worth having regardless of the cost. Dad, if we don't stand up to companies like Meridian, they'll keep hurting people. They'll keep putting workers in danger and firing anyone who speaks up. And if we do stand up to them, they'll destroy us. He leaned forward, his voice urgent. Elena, you're young, you're educated, you have options. If this lawsuit fails, you can move to another state, start over, build a career somewhere else. But your mother and I? This is our home. These are our neighbors. This is the community where we plan to spend the rest of our lives. The weight of his words settled over me like a heavy blanket. For the first time since taking David's case, I was forced to confront the possibility that my pursuit of justice might be a form of selfishness disguised as righteousness. What do you want me to do? I asked quietly. I want you to think about whether this case is really about helping David Santos, or whether it's about proving to yourself and to us that you can succeed at something. The question hit me harder than any accusation could have. Was I fighting for David and the other workers at Meridian, or was I fighting to prove that my parents had been wrong to doubt me? Was my commitment to justice genuine, or was it motivated by a desire to finally win their approval through a spectacular legal victory? That night, I called David Santos and asked him to meet me at the legal aid clinic. When I explained what had happened with my father's contract, his response was immediate and unequivocal. We need to drop the case, he said. I never wanted other families to get hurt because of my problems. David, that's exactly what Meridian wants. They retaliated against my father specifically to pressure us into giving up. Maybe they were right to pressure us, he said quietly. Look at what's happening. Your father loses his business, my family is still struggling, and Meridian is still operating exactly the way they were before. What have we accomplished except making things worse? I spent the next 3 days in a state of paralysis, unable to focus on my final exams, unable to sleep, unable to find a clear path forward. Rebecca Chen called repeatedly, but I couldn't bring myself to answer the phone. I knew she would tell me that corporate defendants always tried to divide their opponents, that backing down now would only encourage future retaliation, that justice required persistence in the face of intimidation. But I also knew that my pursuit of justice was causing real harm to real people who had never asked to be part of this fight. The decision was ultimately made for me by an unexpected source. Rosa Martinez, the cleaning woman who had witnessed the company's discussions about making an example of David, called me on Friday evening. Elena, I heard what happened to your father. I heard that you're thinking about dropping the case. Rosa, I can't ask people to sacrifice their livelihoods for this lawsuit. It's not fair. You're not asking, she said firmly. We're choosing. There are 12 workers here who are ready to testify about the safety violations, about the retaliation, about the way this company treats people like disposable equipment. Your father getting fired just proves that everything David said was true. But the cost. The cost of fighting is high, Rosa interrupted. But the cost of not fighting is higher. If we give up now, Meridian learns that they can silence anyone by threatening their families. If we fight and win, maybe the next worker who sees something dangerous will feel safe enough to report it. That weekend, I made the hardest decision of my life. I called my father and told him that I was going to continue with the lawsuit, but that I understood if he could never forgive me for choosing David Santos's case over our family security. His response surprised me. Elena, I don't agree with your decision. I think you're taking on a fight you can't win, and I think the cost will be higher than you imagine. But I also know that you're doing what you believe is right, and that's something I raised you to do, even when I don't like the consequences. It was the closest thing to a blessing I was going to get. As I prepared for graduation and the legal battle that would follow, I carried my father's words with me like a talisman against the doubt that threatened to overwhelm me whenever I thought about the magnitude of what we were attempting. I had no idea that the real test was still ahead, or that the courtroom confrontation that would define my career would require me to choose between family loyalty and legal ethics in ways that would challenge everything I thought I knew about right and wrong. Graduation day arrived with the kind of crisp May morning that makes promises feel possible. I sat among my classmates in the university auditorium, wearing the black cap and gown that represented 3 years of 18-hour days, financial struggle, and the constant tension between dreams and doubt. But as Dean Patterson called my name and I walked across the stage to receive my law degree, I couldn't shake the feeling that I was crossing a bridge that was burning behind me. My parents sat in the audience, their faces carrying expressions I had learned to read over the years, pride mixed with apprehension, love tempered by concern about the choices I was making. After the ceremony, during the reception on the campus lawn, my mother hugged me tightly. "We're proud of you, Mija," she whispered. "But we're also scared for you." My father's congratulations were more reserved. "You've accomplished something remarkable, Elena. I just hope you know what you're going to do with it." What I was going to do with it became clear the following Monday morning when I reported to Rebecca Chen's office as her newest associate attorney. The Santos case had grown significantly since I had first walked into the legal aid clinic 6 months earlier. We now represented 14 Meridian workers who had faced retaliation for reporting safety violations, and our investigation had uncovered a pattern of corporate behavior that stretched back nearly a decade. Rebecca had assembled a war room in the conference area adjacent to her office, walls covered with timelines, organizational charts, and photographs of safety violations. The scope of Meridian's systematic misconduct was staggering, but so was the challenge of proving it in court against a company with virtually unlimited legal resources. "Elena, I need you to understand something," Rebecca said during our first official strategy meeting as attorney and associate. "This case is going to define your career, one way or another. If we win, you'll be known as the lawyer who took down Meridian Manufacturing. If we lose, you'll be known as the lawyer who failed spectacularly against Meridian Manufacturing. There's no middle ground." The weight of that reality settled over me as we prepared for what everyone knew would be a brutal legal battle. Meridian had responded to our lawsuit by hiring Kessler, Morrison & Associates, a Chicago-based firm that specialized in defending corporations against employment claims. Their lead attorney, Patricia Kessler, had a reputation for destroying whistleblower cases through aggressive discovery tactics and character assassination of plaintiffs. Our first indication of what we were facing came during the initial discovery phase. Kessler's team filed motions requesting every document related to our investigation, every communication between our office and the plaintiffs, and detailed financial records going back 5 years for each worker we represented. "They're trying to bury us in paperwork," Rebecca explained as we reviewed the discovery requests. "But more than that, they're trying to intimidate our clients by demanding access to their most private information." The intimidation campaign extended beyond legal maneuvers. David Santos called me one evening in panic because a private investigator had been questioning his neighbors about his character and reliability. Rosa Martinez reported that her supervisor at Meridian had suddenly become hypercritical of her work, writing her up for minor infractions that had previously been ignored. They're building a case to discredit our witnesses before we ever get to trial, I told Rebecca after documenting the latest round of harassment reports. That's exactly what they're doing. The question is whether our clients have the strength to withstand this kind of pressure for the months it will take to reach trial. The answer came sooner than we expected. 3 of our 14 plaintiffs withdrew from the case after receiving settlement offers that included confidentiality agreements and non-disparagement clauses. The offers weren't large enough to be life-changing, but they were sufficient to provide temporary financial stability for families who were struggling to survive while unemployed. I don't blame them, David told me after learning that 2 of his former co-workers had accepted settlements. They have kids, mortgages, medical bills. They can't afford to fight a war they might not win. But the defections also strengthened our remaining case in unexpected ways. Each settlement included language that implicitly acknowledged Meridian's liability, and the pattern of targeted settlement offers demonstrated the company's awareness that our allegations had merit. More importantly, the workers who remained committed to the lawsuit became more determined than ever to see it through. They had watched their colleagues accept what amounted to hush money, and they understood that backing down now would validate Meridian's strategy of silencing opposition through economic pressure. The breakthrough in our case came from an unexpected source: my father's terminated electrical contract. While reviewing the documentation of Roberto Vasquez's firing, Rebecca discovered that Meridian had violated their own internal procedures for contractor termination. More significantly, the company had failed to pay my father for work already completed, which constituted a breach of contract that could be pursued separately from the main lawsuit. Elena, your father's case gives us leverage we didn't have before, Rebecca explained. If we can prove that Meridian retaliated against him specifically because of your involvement in the Santos case, it demonstrates a pattern of retaliation that goes beyond individual employment disputes. My father doesn't want to be involved in this lawsuit, I reminded her. He's made that very clear. He doesn't have to be involved in the main case. We can file a separate breach of contract action that focuses on the money Meridian owes him. But the facts of his termination will support our broader argument about the company's retaliatory practices. The ethical complexity of this situation kept me awake at night. Using my father's situation to strengthen our case felt manipulative, even if it was legally sound. But Rebecca was right that Meridian's retaliation against my family demonstrated exactly the kind of corporate overreach that our lawsuit was designed to address. I decided to approach my father directly about the possibility of pursuing his contract claim. We met again at Murphy's Diner, this time for lunch on a Saturday when the usual morning crowd had been replaced by families and teenagers. Dad, Meridian owes you almost $15,000 for work you completed before they terminated your contract. You have a legal right to collect that money. He stirred his coffee slowly, considering my words. Elena, I know they owe me money. But pursuing it means admitting that you were right about them being vindictive and retaliatory. It means acknowledging that they fired me specifically to hurt you. Isn't that what happened? Yes, he said quietly. But admitting it means giving up the pretense that I can still work in this community without being defined by my daughter's lawsuit. The sadness in his voice broke my heart. My father had spent his entire career building a reputation as a reliable, non-controversial contractor who could be trusted to complete projects without creating problems for his clients. My legal career had destroyed that reputation in a matter of months. What if we could get your money back without you having to testify or be directly involved in the main case? I asked. What if we could settle your contract claim quietly, separate from everything else? Would that help your other case? I considered lying to him, telling him that his situation was completely separate from David Santos's lawsuit. But he deserved honesty about the ways that corporate defendants use family connections to pressure their opponents. Yes, it would help. Proving that Meridian retaliated against you strengthens our argument about their pattern of silencing opposition. But Dad, even if it didn't help our case, you still deserve to be paid for work you completed. He was quiet for several minutes, watching the afternoon traffic outside the diner window. Finally, he spoke. Elena, I've spent 3 months being angry at you for putting principles ahead of practical considerations. But watching what Meridian did to me, seeing how they use economic pressure to control people's choices, I'm starting to understand why you think some fights are worth having. Does that mean you'll let us pursue your contract claim? It means I'll let you try to get my money back. But Elena, I want you to understand something. Win or lose, this lawsuit is going to change our family forever. We're not going to be the same people we were before this started. He was right, of course. By the time we walked into that courtroom 6 months later, none of us would be the same. But I had no way of knowing then that the most dramatic changes were still ahead, or that my father's quiet courage in pursuing his contract claim would ultimately provide the key evidence we needed to prove our case against one of the most powerful corporations in the state. The deposition phase of our case began in August, 4 months before our scheduled trial date. Depositions in employment cases are usually routine affairs, attorneys asking scripted questions while court reporters transcribe predictable answers. But Patricia Kessler had transformed our depositions into psychological warfare, designed to break our witnesses before they ever reached the courtroom. David Santos went first, spending 2 grueling days in Kessler's conference room while she dissected every aspect of his life and work history. She questioned his educational background, his previous employment, his financial situation, and his relationships with coworkers. Most devastatingly, she forced him to explain, in excruciating detail, every minor workplace infraction from his 3 years at Meridian. Mr. Santos, isn't it true that you were late to work 7 times in the month before you were terminated? Kessler asked, consulting a thick file of personnel records that Meridian had provided. Yes, but... Isn't it true that your supervisor had spoken to you multiple times about your attendance? Yes, but those conversations were... Just answer the question, Mr. Santos. Were you or were you not counseled about attendance issues? I watched David struggle to explain the context that made these infractions meaningless, that he had been staying late to document safety violations, that his attendance problems occurred on days when he was meeting with OSHA inspectors, that his supervisor's sudden concern about minor issues coincided exactly with his whistleblower activities. But Kessler's strategy wasn't about finding truth, it was about creating doubt. By the end of David's deposition, she had assembled a narrative that portrayed him as a disgruntled employee with performance problems who had fabricated safety concerns to avoid responsibility for his own shortcomings. Rosa Martinez's deposition was even more brutal. Kessler had clearly researched Rosa's immigration history, her family situation, and her financial vulnerabilities. The questioning became so aggressive that Rebecca was forced to object repeatedly to protect Rosa from harassment. Ms. Martinez, you clean offices at night when no one else is around, correct? Yes. So when you claim to have overheard conversations about Mr. Santos, there were no other witnesses to confirm what you heard? The managers, they were talking loud on the phone. I could hear everything. But you were eavesdropping on private conversations while you were supposed to be working? I was cleaning the office. They were talking loud. Ms. Martinez, isn't it possible that you misunderstood these conversations because English is not your first language? The racist undertones of this line of questioning made me furious, but Rosa handled it with dignity that put Kessler's tactics in stark relief. When Rebecca objected to the relevance of Rosa's language skills, Kessler's response revealed the true nature of Meridian's defense strategy. Your Honor, the witness's ability to accurately understand and report English conversations is directly relevant to the reliability of her testimony. What Kessler was really arguing was that Rosa's status as a Latina immigrant made her inherently unreliable as a witness. It was a defense strategy that relied on the jury's potential prejudices rather than the facts of the case. But the most challenging deposition was my own. As the attorney who had initiated the investigation and recruited the witnesses, I was both an advocate for the plaintiffs and a potential witness to Meridian's retaliatory conduct. Kessler spent an entire day probing my motivations, my relationship with the clients, and my family's connections to the Millbrook Heights community. Ms. Vasquez, isn't it true that you encouraged Mr. Santos to file this lawsuit because you wanted to make a name for yourself in the legal community? No, that's not true. I believed his claims had merit based on the evidence he provided. But you're a recent law school graduate with no experience in employment law, correct? I worked extensively with employment cases during my clinical work. Ms. Vasquez, please answer the question. Are you or are you not a recent graduate with no previous experience handling cases of this magnitude? The implication was clear. I was an inexperienced attorney who had manipulated vulnerable workers into pursuing a frivolous lawsuit for my own professional benefit. Kessler was laying the groundwork for a defense that would portray our entire case as the product of legal incompetence and personal ambition. The lowest point came when Kessler began questioning me about my father's terminated contract with Meridian. "Ms. Vasquez, your father Roberto Vasquez was terminated from a contract with Meridian Manufacturing, correct?" "Yes." "And you believe that termination was related to your lawsuit against the company?" Rebecca objected, but I could see where this was heading. Kessler was going to argue that my family's financial interest in the outcome of the case compromised my objectivity as an attorney. "Isn't it true, Ms. Vasquez, that your father stands to gain financially if this lawsuit is successful?" "My father is pursuing a separate breach of contract claim for work he already completed. That's independent of the employment claims. But both cases involve the same defendant, the same law firm, and they both financially benefit your family, correct?" The questioning continued for 6 hours, with Kessler systematically attacking my credibility, my competence, and my motivations. By the end of the day, I felt like I had been psychologically dismantled and reassembled as a caricature of an opportunistic young lawyer exploiting vulnerable workers for personal gain. That evening, I called Rebecca from my apartment, emotionally exhausted and beginning to doubt whether we could survive Kessler's assault on our case. "Elena, what you experienced today is exactly what Kessler does to intimidate opposing counsel," Rebecca said. "She's betting that you'll be so rattled by the deposition process that you'll make mistakes during trial preparation." What if she's right? What if I am in over my head with this case? Do you believe David Santos was illegally fired for reporting safety violations? Yes. Do you believe Meridian has retaliated against workers who tried to protect their colleagues from dangerous conditions? Yes. Then you're not in over your head. You're fighting for something that matters, and Kessler's tactics prove that Meridian knows their conduct was wrong. But doubt is a persistent enemy, and as we moved into the final months before trial, I found myself second-guessing every decision we had made. The case had consumed my life completely. I was working 16-hour days, neglecting my health, and straining my relationships with everyone I cared about. The breaking point came in October when we received Meridian's summary judgment motion, a legal filing that essentially argued that our case was so weak it should be dismissed without a trial. The motion was 127 pages long and included sworn affidavits from dozens of Meridian employees contradicting our witnesses' testimony. Reading through Meridian's version of events was like looking into a funhouse mirror that distorted everything I thought I knew about the case. According to their affidavits, David Santos was a problem employee who had been counseled repeatedly about performance issues. Rosa Martinez was a disgruntled worker who had been caught stealing office supplies. The safety violations we had documented were either routine maintenance issues or had been promptly addressed by management. Most devastating was an affidavit from Frank Harrison, the Meridian supervisor who had terminated my father's contract. According to Harrison, Roberto Vasquez's contract was ended because his work was substandard and behind schedule, not because of any retaliation related to my lawsuit. "They're lying," I told Rebecca as we reviewed the summary judgment motion. "Everything in these affidavits contradicts the evidence we've gathered." "Of course they're lying," Rebecca replied. "But they're lying systematically and convincingly. This is what unlimited legal resources can accomplish. They can create an alternative narrative that sounds plausible if you ignore the timeline and the pattern of retaliation." Fighting the summary judgment motion required us to present our strongest evidence in a concentrated legal argument that would either save our case or end it before we ever reached a jury. We had 30 days to file our response, and those 30 days would determine whether David Santos and the other workers would ever have their day in court. As I worked through the nights preparing our response, surviving on coffee and determination, I kept thinking about something Rosa Martinez had said during her deposition. When Kessler had accused her of lying about the conversations she overheard, Rosa had looked directly at the camera and said, "I know what I heard. I know what happened. And I know the difference between right and wrong." It was that simple moral clarity that had started this entire case, and it was what I held onto as we prepared to fight for our legal lives in a motion that would test everything I believed about justice, truth, and the power of ordinary people to stand up to institutional intimidation. The courtroom showdown was still 2 months away, but the real battle for our case was happening right now, in legal briefs and evidentiary arguments that would determine whether we would even get the chance to present our story to a jury. The summary judgment hearing was scheduled for November 15, exactly 3 weeks before our trial date. Judge Margaret Thornfield, a former prosecutor known for her no-nonsense approach to litigation, would decide whether our case had sufficient merit to proceed to jury trial or whether Meridian's legal team had successfully demonstrated that no reasonable jury could find in our favor. Preparing for the hearing consumed every waking moment of my life. Rebecca and I worked 18-hour days, crafting legal arguments that would distill 14 months of investigation into a coherent narrative that could survive Kessler's systematic assault on our credibility. We had to prove not just that David Santos and the other workers had been illegally retaliated against, but that we had sufficient evidence to convince a jury despite Meridian's alternative explanations for every piece of our case. The challenge was compounded by the discovery that Meridian had been conducting their own investigation of our witnesses, clients, and even our law firm. Private investigators had interviewed former co-workers, neighbors, and anyone else who might provide damaging information about our credibility or the plaintiff's character. "Elena, look at this," Rebecca said, showing me a thick folder that had arrived via courier from Kessler's office. "They've assembled psychological profiles of every witness we plan to call. They know Rosa's immigration history, David's financial problems, your academic record, even details about your parents' marriage and your father's business struggles." The scope of Meridian's research operation was both impressive and terrifying. They had identified every vulnerability, every potential weakness, every aspect of our lives that could be used to undermine our case. It was corporate intelligence gathering at a level that felt more appropriate for international espionage than employment litigation. But the research had also revealed something that Meridian's lawyers hadn't anticipated. Their investigation had uncovered additional evidence of the company's retaliatory practices. In interviewing former Meridian employees, their investigators had documented conversations and incidents that supported our case rather than undermining it. They interviewed Maria Gonzalez, who was fired last year after reporting sexual harassment, Rebecca explained, highlighting sections of the investigative report. According to their own notes, she described the exact same pattern of performance criticism and character assassination that our clients experienced. More significantly, the investigation had revealed that Frank Harrison, the supervisor who had terminated my father's contract, had made statements to other contractors that directly contradicted his sworn affidavit in the summary judgment motion. "Harrison told Jim Morrison from Morrison Electric that your father was terminated specifically because Meridian couldn't have troublemaker families working on their projects," Rebecca continued. "Morrison thought it was inappropriate and mentioned it to several other contractors. This was the smoking gun we needed, direct evidence that my father's termination was retaliatory and that Meridian's stated reasons were pretextual. But getting this information into evidence would require convincing Jim Morrison to testify, potentially jeopardizing his own business relationships with Meridian. I drove to Morrison's shop on a cold Thursday morning, knowing that this conversation could determine the outcome of our entire case. Jim Morrison was a 60-year-old electrical contractor who had worked in Millbrook Heights for 30 years, building a reputation for honesty and quality workmanship. He was also someone who understood the economic pressure that Meridian could exert on local businesses. "Elena, I heard about what happened to your dad," Morrison said when I explained why I was there. "Roberto's a good man, and what Meridian did to him was wrong. But testifying against them? That's asking me to put my business at risk. Mr. Morrison, they lied in their court filings about why my father was terminated. Harrison's statement to you proves that their real motivation was retaliation." Morrison poured coffee from a thermos and considered my request. His shop was filled with the organized chaos of a working contractor, spools of wire, electrical components, and the tools of a trade that required both technical skill and business acumen. "Elena, I've got 18 employees and their families depending on the work I can get. Meridian represents maybe 30% of our annual revenue through direct contracts and referrals. If I testify against them and they decide to blacklist me, I could lose everything I've built." I understood his dilemma completely. It was the same calculation that had kept most Meridian workers silent about safety violations and retaliation. The system was designed to make the cost of truth-telling too high for ordinary people to bear. What if I told you that Meridian is already planning to reduce their local contractor pool and consolidate work with larger, out-of-state companies? I asked, sharing information that Rebecca had discovered during our investigation of Meridian's business practices. Morrison's expression shifted. What do you mean? We found internal communications indicating that Meridian is moving toward exclusive contracts with national electrical firms. They're planning to phase out local contractors over the next 2 years to reduce costs and oversight complications. This information changed the entire dynamic of our conversation. Morrison wasn't just being asked to risk his business relationship with Meridian, he was being asked to provide evidence against a company that was already planning to end that relationship for their own financial benefit. Are you sure about this information? He asked. It's in their own planning documents. Meridian sees local contractors as a liability because you have community connections that make you harder to control. Morrison was quiet for several minutes, processing the implications of what I had told him. Finally, he spoke. Elena, if I testify, I want protection for my employees. I want assurance that if Meridian retaliates against my business, there will be legal recourse. We can include your situation in our retaliation claims if they take action against you for testifying truthfully. And if we lose the case entirely? That was the question I couldn't answer satisfactorily. If our case collapsed, Morrison and anyone else who testified against Meridian would be left vulnerable to economic retaliation with no legal protection. Mr. Morrison, I can't guarantee that we'll win. But I can guarantee that if people like you don't speak up, companies like Meridian will continue to believe they can silence opposition through economic intimidation. He agreed to testify, but only after extracting a promise that we would keep his involvement confidential until absolutely necessary and that we would provide legal support if Meridian retaliated against his business. With Morrison's testimony, we now had direct evidence that contradicted Meridian's sworn statements in their summary judgment motion. But we still had to survive the hearing itself, where Judge Thornfield would decide whether our evidence was sufficient to warrant a jury trial. The night before the hearing, I couldn't sleep. I reviewed our legal brief repeatedly, looking for weaknesses that Kessler might exploit. I practiced answers to the questions I anticipated from the judge. Most importantly, I tried to prepare myself emotionally for the possibility that 14 months of work might end with a single judicial ruling that our case lacked merit. Rebecca found me in the office at 3 a.m., still reviewing documents and making notes. Elena, you need to get some sleep, she said. Tomorrow's hearing isn't about having perfect answers to every question. It's about convincing Judge Thornfield that David Santos and the other workers deserve their day in court. What if we're wrong? What if Kessler is right and we're just inexperienced attorneys who got in over our heads? Rebecca sat down across from me, her expression serious. Elena, in 20 years of practicing employment law, I've learned that the most important cases are often the ones that scare you the most. If this case was easy, someone else would have taken it years ago. She was right, but that didn't make the fear any less real. In 12 hours, we would walk into Judge Thornfield's courtroom and discover whether our fight for justice would continue or whether Meridian's superior resources and legal expertise would end our case before we ever reached a jury. Everything we had worked for, everything our clients had risked, everything my family had sacrificed, it all came down to one hearing that would test whether the legal system could protect workers who dared to challenge corporate power. Judge Margaret Thornfield's courtroom felt like a cathedral of justice, with high ceilings, polished wood panels, and an atmosphere that demanded reverence for the law. As Rebecca and I arranged our files at the plaintiff's table, I could feel the weight of 14 months of preparation condensing into this single moment that would determine our case's survival. Patricia Kessler entered with her usual commanding presence, followed by a team of 3 associates wheeling in document boxes that represented Meridian's unlimited litigation budget. She nodded curtly in our direction, a gesture that managed to convey both professional courtesy and absolute confidence in her ability to destroy our case within the next 2 hours. All rise, the bailiff announced as Judge Thornfield took the bench. At 62, she had the bearing of someone who had seen every possible legal argument and wasn't impressed by theatrical presentations or emotional appeals. Her reputation for cutting through lawyer rhetoric to focus on legal substance was exactly what made this hearing so dangerous for our side. "Good morning, counsel," Judge Thornfield said, settling into her chair and opening the case file. "Ms. Kessler, you may begin your argument for summary judgment." Kessler rose with the fluid confidence of someone who had won dozens of similar hearings. Her argument was a masterpiece of legal precision, systematically dismantling every aspect of our case while maintaining a tone of reasonable objectivity that made her conclusions seem inevitable. Your Honor, plaintiff's counsel would have this court believe that Meridian Manufacturing engaged in a conspiracy to retaliate against workers who reported safety concerns. But the evidence tells a different story entirely. She activated a presentation screen that displayed David Santos's personnel file, complete with documentation of attendance problems, performance issues, and supervisor complaints that stretched back months before his termination. David Santos was not a whistleblower who was illegally fired for protecting his coworkers. He was a problem employee who consistently violated company policies and created workplace disruptions. When Meridian finally terminated him for legitimate performance reasons, Mr. Santos fabricated a retaliation claim to avoid accountability for his own shortcomings. The presentation continued with similar character assassinations of our other witnesses. Rosa Martinez became a disgruntled employee with her own performance problems. The safety violations we had documented became routine maintenance issues that had been promptly addressed by management. Our entire case was reframed as the product of opportunistic workers manipulated by inexperienced attorneys seeking to make names for themselves. Most concerning, Your Honor, is the apparent conflict of interest created by plaintiff's counsel Elena Vasquez, whose own family stands to benefit financially from a successful outcome in this case. Kessler displayed documents showing my father's terminated contract and our separate breach of contract claim, arguing that my personal financial interest compromised my objectivity as an attorney representing the workers. When attorneys have personal stakes in the outcome of litigation, the integrity of the entire case becomes suspect. Ms. Vasquez cannot credibly represent workers' interests when her family's financial recovery depends on vilifying the same defendant. The argument was devastating in its comprehensiveness and persuasive in its logic. If I hadn't lived through the investigation myself, if I hadn't seen the evidence firsthand, I might have been convinced by Kessler's alternative narrative. Judge Thornfield's questions during Kessler's presentation were sharp and probing, but they focused on legal standards rather than factual disputes. She wanted to understand whether our evidence met the minimum threshold for surviving summary judgment, not whether our version of events was more credible than Meridian's. Ms. Kessler, even accepting your characterization of the evidence, don't the temporal proximity between safety complaints and terminations create genuine issues of material fact regarding causation? Your Honor, temporal proximity alone is insufficient to establish retaliation when there are legitimate, well-documented performance reasons for the terminations. Meridian should not be required to retain problem employees simply because they filed complaints, regardless of the merit of those complaints. When Kessler finished her presentation, the courtroom felt heavy with the weight of her arguments. She had transformed our David versus Goliath narrative into a story of corporate responsibility versus frivolous litigation, making Meridian appear reasonable and our clients appear opportunistic. Ms. Chen, you may respond, Judge Thornfield said. Rebecca stood with deliberate calm, her presence a stark contrast to Kessler's aggressive confidence. Where Kessler had used multimedia presentations and dramatic rhetoric, Rebecca relied on quiet intensity and meticulous attention to detail. Your Honor, defense counsel would have this court ignore a fundamental principle of employment law: patterns matter more than individual incidents. She moved to the presentation screen and displayed a timeline that showed not just our clients' cases, but the broader pattern of retaliation that we had documented across Meridian's operations. In the past 5 years, Meridian has terminated or disciplined 37 workers within 6 months of their filing safety complaints. In each case, the company cited performance problems that had been previously overlooked or tolerated. In each case, the workers were subsequently blacklisted from employment opportunities throughout the region. The timeline was compelling because it showed the systematic nature of Meridian's retaliation. Individual cases might be explained by legitimate performance concerns, but the pattern revealed an unmistakable corporate strategy of silencing opposition through economic intimidation. Defense counsel argues that David Santos was a problem employee, but she fails to mention that his alleged performance problems were never documented until after he filed safety complaints. She argues that Rosa Martinez is unreliable, but she cannot explain why Ms. Martinez's testimony is corroborated by documentary evidence that Meridian produced in discovery. Rebecca's most powerful moment came when she addressed the conflict of interest allegations regarding my family's situation. Your Honor, defense counsel's attack on Ms. Vasquez's ethics actually proves our case rather than undermining it. Roberto Vasquez was terminated from his contract specifically because of his daughter's legal work, a fact that Meridian's own supervisor admitted to other contractors in the community. She presented Jim Morrison's sworn affidavit, which had been filed under seal the previous day. Morrison's statement directly contradicted Harrison's deposition testimony and provided clear evidence that my father's termination was retaliatory. This is not a conflict of interest, Your Honor. This is additional evidence of Meridian's pattern of using economic pressure to silence opposition. They retaliated against Mr. Vasquez specifically to intimidate his daughter and pressure our law firm to abandon our clients. Judge Thornfield's demeanor shifted subtly as Rebecca presented this evidence. For the first time during the hearing, she seemed genuinely surprised by information that hadn't been fully developed in the written briefs. Ms. Chen, when was this affidavit obtained, and why wasn't it included in your original summary judgment response? Your Honor, Mr. Morrison only agreed to testify after defense counsel's own investigation revealed that Meridian was planning to terminate local contractor relationships regardless of individual performance. He was reluctant to jeopardize his business until he learned that the relationship was already doomed. This revelation created exactly the kind of dramatic moment that Rebecca had been building toward. Meridian's own investigation had uncovered evidence that supported our case, and their aggressive discovery tactics had actually strengthened our position rather than undermining it. Kessler requested permission to respond to the new evidence, but Judge Thornfield cut her off with a gesture that suggested she had heard enough arguments from both sides. Counsel, I've reviewed your briefs thoroughly, and I've heard your presentations this morning. This case presents genuine disputes of material fact that cannot be resolved on summary judgment. While defense counsel has raised legitimate questions about plaintiff's evidence, those questions are appropriate for jury consideration rather than judicial determination. My heart stopped as I processed the meaning of her words. She was denying Meridian's summary judgment motion. Our case would proceed to trial. However, Judge Thornfield continued, I am concerned about the complexity of this case and the potential for prejudicial evidence to overwhelm substantive legal issues. I'm ordering a bifurcated trial structure. Liability will be determined first, followed by a separate proceeding on damages if plaintiffs prevail. Rebecca squeezed my hand under the table as the judge concluded her ruling. We had survived the summary judgment hearing, but we had also been put on notice that Judge Thornfield would maintain tight control over our trial presentation. Every piece of evidence, every witness, every argument would be scrutinized for relevance and prejudicial impact. As we packed our files after the hearing, Kessler approached our table with an expression that combined professional courtesy with unmistakable threat. Congratulations on surviving summary judgment, she said to Rebecca. I look forward to presenting this case to a jury who will understand the difference between legitimate employment decisions and frivolous retaliation claims. Walking out of the courthouse that November morning, I felt simultaneously victorious and terrified. We had won the right to present our case to a jury, but we had also committed ourselves to a trial that would test every aspect of our preparation, our credibility, and our ability to convince 12 ordinary citizens that corporate power could be challenged successfully. The real battle was just beginning, and everything we had accomplished so far would be meaningless if we couldn't persuade a jury that David Santos and the other workers deserved justice rather than corporate intimidation. Trial preparation consumed the 3 weeks between our summary judgment victory and jury selection. Rebecca and I worked with the intensity of surgeons preparing for a life-saving operation, knowing that every decision we made about witnesses, evidence, and trial strategy would determine whether 14 months of investigation would culminate in justice or devastating failure. Our biggest challenge was distilling an enormously complex case into a narrative that 12 jurors could understand and believe. We had hundreds of documents, dozens of potential witnesses, and a timeline that stretched back nearly 5 years. But trials are storytelling competitions, and the side that tells the most compelling story usually wins, regardless of the underlying legal merits. Elena, we need to decide on our core message, Rebecca said during one of our late-night strategy sessions. What do we want the jury to remember when they go into deliberation? I had been thinking about this question for weeks. Our case wasn't really about employment law or corporate liability. It was about whether ordinary people could challenge institutional power without being destroyed in the process. Our message is that Meridian used fear to silence workers who tried to protect their colleagues from dangerous conditions, I said. David Santos and the others weren't troublemakers or opportunists. They were people who saw something wrong and found the courage to speak up, knowing it would cost them. And what's Meridian's counternarrative? That we're inexperienced attorneys who manipulated disgruntled employees into filing frivolous claims for our own professional benefit. The challenge was that both narratives contained elements of truth. David Santos had indeed been an imperfect employee with some legitimate performance issues. I was indeed an inexperienced attorney whose family had been directly affected by Meridian's retaliation. The question was which version of the truth would resonate more strongly with the jury. Jury selection began on December 3 in Judge Thornfield's packed courtroom. The venire included farmers, teachers, retirees, small business owners, and factory workers, a cross-section of central Illinois that would ultimately decide whether corporate power or worker protection would prevail in this case. Kessler approached voir dire with surgical precision, identifying and eliminating any potential juror who might be sympathetic to workers' rights or skeptical of corporate authority. She asked questions about union membership, previous employment disputes, and attitudes toward litigation in ways that revealed her deep understanding of jury psychology. "Mr. Patterson, have you or anyone in your family ever filed a lawsuit against an employer?" she asked a middle-aged man who worked as a maintenance supervisor. "No, ma'am. I believe in handling problems directly with management rather than running to lawyers." "And in your experience, are workplace problems usually the result of management failures or employee performance issues?" Patterson's answer was exactly what Kessler wanted. "In my experience, most workplace conflicts could be avoided if employees just did their jobs and followed the rules." Rebecca's approach to jury selection was more subtle but equally strategic. Rather than trying to identify obviously sympathetic jurors, she looked for people who demonstrated independence of thought and willingness to hold authority figures accountable. "Ms. Rodriguez, tell me about a time when you had to make a difficult decision that went against what others expected of you," Rebecca asked a young teacher. "I once reported a colleague for inappropriate behavior with students, even though it meant creating conflict in my workplace and potentially damaging my career prospects." "How did you decide that reporting was the right thing to do?" "I realized that protecting the students was more important than protecting my own comfort or professional relationships." By the end of jury selection, we had 12 jurors and 4 alternates who represented a reasonable cross-section of the community. More importantly, we had identified the key themes that would resonate with this particular group: personal responsibility, protection of vulnerable people, and skepticism toward institutional authority that operated without accountability. Opening statements were scheduled for December 5, and Rebecca spent the weekend crafting a presentation that would introduce our case in terms that connected emotionally with the jury while remaining legally precise. "Ladies and gentlemen," Rebecca began, standing directly in front of the jury box without notes or visual aids, "this case is about what happens when ordinary people find the courage to speak truth to power." She introduced David Santos not as a perfect employee but as a working father who had risked his livelihood to protect his colleagues from dangerous conditions. She described Rosa Martinez as a woman who had witnessed corporate executives discussing how to make an example of workers who reported safety violations. The defendants will tell you that Mr. Santos and the other plaintiffs were problem employees who deserved to be fired for legitimate performance reasons. But the evidence will show you something different: a systematic campaign to silence workers who threatened Meridian's profits by insisting on basic safety protections. Rebecca's most powerful moment came when she addressed the elephant in the room: my family's involvement in the case. The defense will try to convince you that this lawsuit is somehow illegitimate because attorney Elena Vasquez's father was also retaliated against by Meridian. But Roberto Vasquez's situation doesn't undermine our case, it proves it. When a company is willing to destroy an electrical contractor's business just to intimidate his daughter, what does that tell you about how they treat their own employees? Kessler's opening statement was a masterpiece of corporate damage control, acknowledging problems while deflecting ultimate responsibility. "Ladies and gentlemen, Meridian Manufacturing is not a perfect company. No large employer is. But imperfection is not the same as illegality, and workplace conflicts are not the same as retaliation." She systematically attacked each of our plaintiffs' credibility, presenting David Santos as a disgruntled employee who had fabricated safety concerns to avoid accountability for his own performance problems. Mr. Santos was late to work repeatedly, argued with supervisors, and created workplace disruptions that affected his colleagues' productivity. When Meridian finally terminated him for these legitimate reasons, he decided to blame the company rather than accept responsibility for his own choices. Kessler's strategy was to overwhelm the jury with documentation of every minor workplace infraction our clients had ever committed, creating the impression that their terminations were not only justified but overdue. The plaintiff's attorneys would have you believe that any employee who files a safety complaint becomes untouchable, regardless of their subsequent behavior or performance. But that's not how employment law works, and it's not how responsible businesses operate. Both opening statements were effective in different ways. Rebecca had established an emotional connection with the jury and introduced the broader themes of corporate accountability and worker protection. Kessler had raised legitimate questions about our clients' credibility and planted seeds of doubt about our motivations as attorneys. As the first day of trial concluded, I felt the weight of everything we had worked towards settling over me like a heavy blanket. For 14 months, this case had existed primarily in documents, depositions, and legal arguments. Now it would be tested in the most demanding forum possible, 12 citizens who would ultimately decide whether our pursuit of justice had been worth the enormous costs it had imposed on everyone involved. That evening, I called my parents to let them know that trial had finally begun. My father's response was characteristically practical. "Elena, I know you believe in what you're doing, but I want you to be prepared for the possibility that believing in something isn't always enough to win." "I know, Dad. But I also know that if we don't fight, nothing will ever change." "Maybe," he said quietly. "But change always comes with a price, and sometimes that price is higher than the people fighting are prepared to pay." He was right, of course. As I prepared for the next day's witness testimony, I wondered whether the price we were paying, in family relationships, career prospects, and emotional exhaustion, would ultimately be worth whatever outcome we achieved. But David Santos and the other workers were depending on us to present their stories with clarity and conviction. For the next week or two, our courtroom would become the arena where corporate power and individual courage would clash in the most fundamental way possible, through the testimony of real people telling their truth before a jury of their peers. The real test was just beginning, and everything we had accomplished so far would be meaningless if we couldn't persuade 12 strangers that justice was more important than corporate convenience. David Santos took the witness stand on the second day of trial, carrying himself with the careful dignity of someone who understood that his credibility would determine the outcome of our entire case. As he raised his right hand to be sworn in, I could see the weight of 14 months of preparation, investigation, and personal sacrifice settling on his shoulders. Rebecca began her direct examination with questions designed to humanize David for the jury: his background, his family, his 3 years of reliable service at Meridian before the safety violations began to escalate. "Mr. Santos, what made you decide to document the safety problems you observed at Meridian?" Rebecca asked. "My co-worker Miguel lost 2 fingers when a safety guard failed on the metal press," David replied, his voice steady but emotional. "The guard had been broken for weeks, but we were told to keep using the machine because stopping production would cost money. After Miguel's accident, I realized that someone had to speak up." David's testimony methodically walked through his documentation process: the photographs of broken equipment, the safety reports he filed with supervisors, the meetings with OSHA representatives that somehow never resulted in meaningful changes. "Did you understand that reporting these safety violations might jeopardize your employment?" Rebecca asked. "Yes, I understood the risk. But I also understood that staying silent meant watching my friends get hurt." The power of David's testimony came from its understated courage. He didn't present himself as a hero or a perfect employee. He acknowledged his attendance problems, his occasional conflicts with supervisors, his frustration with workplace policies. But he also made clear that his safety reporting was motivated by genuine concern for his colleagues rather than personal grievance. Kessler's cross-examination was surgical in its precision, focusing relentlessly on David's employment record and the timeline of his performance problems. "Mr. Santos, isn't it true that you were late to work 7 times in the month before your termination?" "Yes, but..." "Just answer the question, Mr. Santos." 7 times, correct?" "Yes." "And isn't it true that your supervisor had spoken to you multiple times about your attitude toward company policies?" "He spoke to me about following safety procedures that I thought were inadequate." "Mr. Santos, please answer the question I asked." Did your supervisor counsel you about your attitude? Kessler's strategy was to strip away the context that gave David's actions meaning, reducing his safety advocacy to a pattern of insubordination and poor performance. By the end of her cross-examination, she had created doubt about David's motivations and credibility that would be difficult for us to overcome. Rosa Martinez's testimony was equally compelling but more vulnerable to attack. Her limited English and her obvious nervousness on the witness stand made her appear less confident than David, despite the crucial nature of her evidence. Ms. Martinez, please tell the jury what you heard Mr. Harrison say during his phone call on the night Mr. Santos was terminated, Rebecca prompted. He said they needed to make example of David so other workers wouldn't get ideas about going to government, Rosa replied, her accent thick with emotion. Were you supposed to be in the office during this conversation? I was cleaning. It's my job to clean offices at night. How clearly could you hear this conversation? Very clear. Mr. Harrison was talking loud, upset about something. Kessler's cross-examination of Rosa was more aggressive than her questioning of David, reflecting the racist undertones that had characterized her entire approach to the case. Ms. Martinez, English is not your first language, correct? I speak English good enough for my job. But you sometimes misunderstand conversations, especially when people are speaking quickly or using technical terms. I understand what I heard. Ms. Martinez, isn't it possible that you misinterpreted Mr. Harrison's conversation because you were listening to a private business discussion in your second language? The objection I wanted to make stuck in my throat as I watched Rosa's composure begin to crack under Kessler's systematic assault on her credibility. This was exactly the kind of witness intimidation that corporate defendants use to silence working-class witnesses who lack the education or confidence to defend themselves against aggressive questioning. But Rosa's response surprised everyone in the courtroom. I clean offices for 20 years, she said, looking directly at Kessler. I hear many conversations. I know the difference between business talk and planning to hurt people. Mr. Harrison was planning to hurt David and send message to other workers. The quiet dignity of Rosa's response created a moment of silence in the courtroom that felt like a rebuke to Kessler's tactics. Even Judge Thornfield seemed moved by Rosa's refusal to be intimidated. Our strongest witness was Jim Morrison, the electrical contractor who had overheard Frank Harrison's admission about my father's retaliatory termination. Morrison's testimony was devastating to Meridian's defense because it directly contradicted Harrison's sworn deposition testimony. Mr. Morrison, please tell the jury what Mr. Harrison told you about Roberto Vasquez's contract termination, Rebecca said. Harrison said they couldn't have troublemaker families working on Meridian projects. He said they needed to send a message that going after the company would have consequences for the whole family. Did you understand this to mean that Mr. Vasquez was terminated because of his daughter's legal activities? Yes, that was exactly what Harrison meant. He was bragging about how they had shut down the lawyer's father to pressure her into dropping the case. Kessler's cross-examination of Morrison was more restrained, perhaps recognizing that attacking a respected local businessman might backfire with the jury. Mr. Morrison, you've done business with Meridian for several years, correct? Yes. And you hope to continue doing business with them in the future? I hope to do business with companies that treat people fairly. Morrison's response was perfect. It acknowledged his business relationship with Meridian while making clear that his testimony was motivated by principle rather than profit. The most difficult moment of the trial came when I was called to testify about my investigation and my family's involvement in the case. Taking the witness stand as both an attorney and a witness felt surreal, like stepping outside my professional role to become a character in the story I had been telling. Rebecca's direct examination focused on my investigation methodology and the evidence we had gathered, but I knew that Kessler's cross-examination would be the real test of my credibility. Ms. Vasquez, you initiated this lawsuit within months of graduating from law school, correct? Kessler began. Yes. And this is your first major employment case? Yes, but I worked extensively with employment issues during my clinical work in law school. Ms. Vasquez, isn't it true that you encouraged Mr. Santos to file this lawsuit because you saw it as an opportunity to establish your reputation as a plaintiff's attorney? No, that's not true. I believed his claims had merit based on the evidence he provided. But you also stood to benefit professionally from a high-profile victory against a major corporation? The question hit at the heart of Kessler's strategy, portraying me as an opportunistic young lawyer who had manipulated vulnerable workers for personal gain. Ms. Kessler, I took this case because I believed David Santos and the other workers had been illegally retaliated against for protecting their colleagues. Any professional benefit was secondary to that consideration. Ms. Vasquez, when your father's contract was terminated by Meridian, did that make this case personal for you? It made it clear that Meridian was willing to retaliate against families to silence opposition. That strengthened my conviction that we were fighting the right battle. But it also gave you a personal financial interest in the outcome of this litigation? My father's contract claim is separate from the workers' retaliation claims. Our family's situation doesn't change the fact that David Santos was illegally fired for reporting safety violations. By the time I stepped down from the witness stand, I felt emotionally drained but cautiously optimistic about how my testimony had been received. The jury had seen me acknowledge the personal stakes while maintaining that our case was motivated by principle rather than profit. As we prepared to rest our case, Rebecca and I reviewed the testimony we had presented over 4 days of trial. We had told a coherent story of corporate retaliation supported by credible witnesses and documentary evidence. But we had also seen how effectively Kessler could attack our witnesses' credibility and create doubt about our motivations. Elena, how do you think we did? Rebecca asked as we packed our files after the 4th day of testimony. I think we proved our case, but I'm not sure we proved it beyond the doubt that Kessler has created. That's the challenge with every employment case. The facts are usually on the worker's side, but corporate defendants have unlimited resources to create alternative explanations and attack credibility. Tomorrow would bring Meridian's defense case, where they would present their version of events through supervisors, managers, and corporate officials who would systematically contradict everything our witnesses had testified to. The real battle was just beginning, and the outcome would depend on which narrative the jury found more persuasive, corporate responsibility or worker manipulation. Meridian's defense case began on Monday morning with Frank Harrison taking the witness stand. As the supervisor who had terminated David Santos and overseen much of the alleged retaliation, Harrison was the linchpin of their defense strategy. Kessler had clearly prepared him extensively, and his testimony was delivered with the polished confidence of someone who had rehearsed every answer. Mr. Harrison, please describe David Santos's performance during his final months of employment, Kessler began. Mr. Santos had become increasingly problematic, Harrison replied, consulting notes that made his testimony appear spontaneous. He was frequently late, argumentative with supervisors, and disruptive to workplace morale. His safety complaints appeared to be motivated more by hostility toward management than genuine concern for his coworkers. Harrison's testimony systematically dismantled our case by providing alternative explanations for every piece of evidence we had presented. The safety violations David documented were characterized as routine maintenance issues that had been promptly addressed. Rosa Martinez's overheard conversation was reframed as a discussion about legitimate performance management. The pattern of retaliation we had identified was explained as coincidental timing between legitimate terminations and frivolous complaints. Mr. Harrison, did you ever instruct anyone to retaliate against employees who filed safety complaints? Kessler asked. Absolutely not. Meridian takes safety concerns seriously, and we encourage workers to report any issues they observe. We would never punish someone for following proper safety procedures. Rebecca's cross-examination was the most crucial moment of our entire trial. She needed to expose Harrison's lies without appearing to attack him personally, and she had to do it using only the evidence we had been able to gather despite Meridian's superior resources. Mr. Harrison, you testified that Mr. Santos's safety complaints were frivolous. Are you aware that OSHA cited Meridian for 3 of the violations he reported? Harrison's confidence wavered slightly. Those citations were for minor technical violations that posed no real danger to workers. Mr. Harrison, a citation for missing safety guards on heavy machinery is minor? The guards were temporarily removed for maintenance and would have been replaced promptly. Mr. Harrison, OSHA's investigation found that those guards had been missing for over 6 weeks. Does 6 weeks constitute prompt replacement? Rebecca continued to chip away at Harrison's credibility, using OSHA reports, internal company documents, and timeline evidence to expose the contradictions in his testimony. But the most devastating moment came when she confronted him about his conversation with Jim Morrison regarding my father's contract termination. "Mr. Harrison, do you know Jim Morrison from Morrison Electric?" "Yes, we've done business with his company." "Did you have a conversation with Mr. Morrison about Roberto Vasquez's contract termination?" Harrison hesitated, clearly aware that Morrison had testified against him. "I may have mentioned the contract situation." "Did you tell Mr. Morrison that Meridian couldn't have troublemaker families working on company projects?" "I don't recall using those specific words." "Mr. Harrison, are you saying that Mr. Morrison committed perjury when he testified under oath about your conversation?" "I'm saying that conversations can be misinterpreted, especially when people have their own motivations for remembering things in particular ways." Rebecca's final question was delivered with quiet intensity that made the entire courtroom lean forward. "Mr. Harrison, if David Santos's termination was based solely on legitimate performance concerns, why did you feel the need to discuss making an example of him with corporate headquarters?" "I never had any such discussion." "Mr. Harrison, are you willing to swear under oath that you never used the phrase, 'make an example,' in connection with Mr. Santos's termination?" Harrison's pause before answering was long enough to create doubt in every juror's mind. "I don't recall using that specific phrase." The remainder of Meridian's defense case consisted of corporate officials and supervisors who provided sanitized versions of company policies and procedures. They painted a picture of a responsible employer that took safety concerns seriously, treated workers fairly, and operated according to established protocols for performance management. But their testimony felt scripted and defensive compared to the raw emotion and specific details that our witnesses had provided. Corporate executives speaking from prepared notes could not match the credibility of workers like Rosa Martinez, who had risked their livelihoods to tell the truth about what they had witnessed. Closing arguments began on Thursday afternoon. Rebecca's presentation was a masterpiece of narrative construction that wove together all the evidence we had presented into a coherent story of corporate retaliation and worker courage. "Ladies and gentlemen, this case is about a simple question. What happens when ordinary people find the courage to challenge powerful institutions?" She walked the jury through David Santos's documentation of safety violations, Rosa Martinez's witness testimony about corporate discussions, and Jim Morrison's revelation about the retaliation against my family. The defendants want you to believe that this is all coincidence, that David Santos was fired for performance problems that coincidentally emerged after he reported safety violations, that Rosa Martinez coincidentally misunderstood conversations about making examples of troublesome workers, that Roberto Vasquez's contract was coincidentally terminated just as his daughter was investigating the company. Rebecca's voice rose with controlled passion as she reached the climax of her argument. "But there are no coincidences here. There is only a systematic campaign to silence workers who threatened Meridian's profits by insisting on basic safety protections. Your verdict will determine whether corporations can continue to use economic intimidation to suppress the truth, or whether ordinary people have the right to speak up without being destroyed." Kessler's closing argument was equally powerful but took the opposite approach, focusing on legal standards and burden of proof rather than emotional appeals. "Ladies and gentlemen, you have heard a compelling story from plaintiffs' counsel, but compelling stories are not the same as legal proof. The plaintiffs must prove retaliation by a preponderance of the evidence, not by asking you to assume that correlation equals causation." She systematically addressed each piece of our evidence, providing alternative explanations that emphasized the weakness of circumstantial proof and the credibility problems with our witnesses. David Santos was not a heroic whistleblower, he was a problem employee who fabricated retaliation claims to avoid accountability. Rosa Martinez did not witness a corporate conspiracy, she misunderstood a business conversation conducted in her second language. Elena Vasquez is not a crusading advocate for worker rights, she is an inexperienced attorney who manipulated vulnerable clients for personal and professional gain. Kessler's conclusion was designed to make the jury feel responsible for protecting legitimate business interests against frivolous litigation. Your verdict will be watched by employers throughout this region who need to know that they can make legitimate business decisions without fear of costly lawsuits from disgruntled employees. The plaintiffs are asking you to second-guess employment decisions made by experienced managers based on incomplete information and emotional testimony. That is not justice, that is judicial activism. After closing arguments, Judge Thornfield provided jury instructions that would guide the deliberation process. The legal standards for proving retaliation were complex, requiring the jury to determine whether safety reporting was a substantial motivating factor in the employment decisions and whether Meridian's stated reasons were pretextual. As the jury retired to deliberate, I felt the strange emptiness that follows months of intense preparation. Everything we could do had been done. 14 months of investigation, depositions, motions, and trial testimony had been distilled into 12 citizens' collective judgment about credibility, causation, and corporate responsibility. Rebecca and I waited in the courthouse cafeteria, drinking coffee and trying to read meaning into the length of deliberation. Quick verdicts usually favored defendants in employment cases, while longer deliberations suggested that jurors were seriously considering the evidence rather than dismissing the claims outright. After 6 hours, the jury returned with questions about the legal standard for proving retaliation and the relationship between individual termination decisions and corporate policy. Judge Thornfield's answers were carefully neutral, but the questions suggested that the jury was grappling with exactly the issues we had hoped they would consider. At 4:30 p.m. on Friday afternoon, the bailiff announced that the jury had reached a verdict. As we returned to the courtroom for the final time, I could see my parents sitting in the gallery behind us. They had attended every day of trial, watching their daughter fight a battle they had never understood but had come to respect. The jury foreman stood with the verdict form in his hands, and Judge Thornfield asked the question that would determine whether our pursuit of justice had been vindicated or whether Meridian's superior resources had prevailed. Has the jury reached a verdict? We have, Your Honor. Please read the verdict. The foreman's voice was steady as he announced the outcome that would define my career and determine whether David Santos, Rosa Martinez, and the other workers would finally receive justice for the retaliation they had endured. In that moment, as the words of the verdict echoed through Judge Thornfield's courtroom, I understood that my parents had been both right and wrong about the wisdom of fighting battles you might not win. They had been right that such battles always come with costs that extend far beyond the individual fighters. But they had been wrong to believe that some fights aren't worth having regardless of the outcome. Standing there, waiting to hear whether we had won or lost, I knew that I had become exactly the person I was meant to be, someone willing to stand up for justice even when the odds were overwhelming and the personal costs were severe. And for the first time in my life, I could see in my parents' eyes that they finally understood why some principles are worth defending, no matter what it costs to defend them. Up next, you've got 2 more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out.